Good morning. The Committee on Judiciary and Civil Jurisprudence will come to order. The clerk will call the roll.
Leach,
Here.
Johnson,
Here.
Dutton, Moody, Landgraf, Schofield, Gonzalez, Flores, Hayes, LaHood, Dyson, Quorum's present.
Good morning, members. Good morning to those of you who are joining us here at the Capitol and to those who are tuned in online. We appreciate you taking part in our committee hearing this morning. As a reminder, anyone present here in the building wishing to testify before the committee, please register at the kiosks located in the hallways behind the hearing rooms. If you require assistance in registering, testifying, you could see our clerk Cassidy, our assistant clerk Michael down here. We're happy to help. A few housekeeping items before we get going this morning. The chair refers House Bill 1928 to the Subcommittee on Family and Fiduciary Relationships. Members, House Bill 1928 by Representative Gerdes is relating to certain costs associated with statutory probate court proceedings. House Bill 1928 was referred to the Judiciary Committee. In reviewing the bill, the parliamentarian's office realized that it should have been referred directly to the Subcommittee on Family and Fiduciary Relationships. So rather than having to correct the referral on the House floor, I've agreed to refer the bill directly to our subcommittee at this morning's Judiciary hearing. And so that's what I'm doing. Again, the chair refers House Bill 1928 to the Subcommittee on Family and Fiduciary Relationships. For planning purposes, for those who are here in the room and other members in their offices who are preparing to lay out bills in front of our committee this morning, we're going to start with invited testimony from the presiding judge of the Court of Criminal Appeals, Judge David Shank. The judge could not make it at our organizational meeting a couple weeks ago because of oral arguments, but we're glad you're here this morning. And if you want to go ahead and come make your way to the dais here in front of us, we look forward to your testimony. After that invited testimony, we're going to take up House Bill 865 by Speaker Moody. One of Speaker Moody's witnesses has to hit the road, and that bill should go pretty quickly. And then we're going to get on to House Bill 748. And we'll see how far we can get before we hit the floor at 10 a.m. Members, any questions or comments this morning? Okay. With that, the chair recognizes and welcomes to the committee the Honorable David Shank, presiding judge of the Court of Criminal Appeals of the state of Texas. Welcome. We're glad you're here. We look forward to working with you. Congratulations on the new role. And this committee has over the years enjoyed a great working relationship with the Supreme Court and the Court of Criminal Appeals. We welcome you this morning and look forward to hearing from you.
Thank you very much, Mr. Chairman, and thank you for the invitation to come. I appreciate your flexibility on scheduling. I don't have much planned to say to you. I'd be happy to answer any questions that you have. And I know that the members of my court, the Supreme Court, and all the judiciary appreciate very much the hard work that you and members of this committee and all the legislature put in to ensuring that we have the best judiciary in the state that we can possibly have. But I'm here to tell you we have some challenges, and we would very much appreciate your support in that. I believe you've heard from the Chief Justice that judicial salaries are presenting a serious problem. I will tell you, having served for 8 years on an appellate court and as chair of the State Commission on Judicial Conduct, I think that issue should be front and center for this session. We have a serious challenge attracting the kind of talent we need, particularly in some of our urban centers. Mr. Chairman, I believe you had a bench come open in Collin County recently. I'm informed we had a grand total of 3 applicants for that bench. And it's not something that's going to be fixed overnight, but I will submit to you, I do not think 15% is going to do it.
Agreed.
You need really, in my experience, 3 things to make a good judge. You need somebody who's intelligent, you need someone who's honest, and you need someone who's going to work hard. Trying to find all 3 of those things and someone that's willing to take the salary at present, 49th out of 50 jurisdictions in a major city like Dallas or Houston, is very difficult. And we can't make them grow taller. We can't make them get smarter. We can sanction them, and when I was chairing the Conduct Commission, we were doing it a lot. But the real problem we have is that commission needs reform. And I'm speaking now personally about my own experiences, and from my own perspective, it's too big, it's too slow, and you have put over it a court from which there is no review, that has made it impossible to enforce the canons governing coming to work and doing your job. I recently issued an opinion proposing to colleagues on my court that we address that matter directly and that we present to the Speaker of the House, the governor, and the lieutenant governor when we have judges, and we have them, that are habitually refusing to carry out the functions of the office. So I would appreciate very much anything you could do to help with that. We are here to work with you hand in hand, as I believe the Senate has made clear, that any pay raise should go along with accountability. Good judges want that accountability too, and we will need your help to make it happen. And I want you to make it clear that I'm committing myself to give you that help. Secondly, my court. I just grabbed last night before coming here the data from 1980, the year before we created appellate jurisdiction in the intermediate courts of appeals for the casework that was coming through my court. At that time, it was 6,400 cases a year, which we thought was too much, so we got help from the intermediate courts of appeals. Last year, we did 7,000 and change, most of which is writ work, habeas applications for people who are currently in state custody. Now, that's important work, but my court is doing it directly. And if you do the math, 9 judges, 7,000 cases a year, and 3,000 of them are not habeas cases. We need help. I've asked for a couple of extraordinary items in our budget to get me some more lawyers, to get some basic funding. I really need that. I am not asking for money for nothing, but we cannot keep up with this pace and deal with the judges we have below us and all the challenges those present without some help.
What is your current staffing? I know there's 9 judges, but what is the staffing at the court right now?
I believe we have, and I'm guessing here, I've been there 9 weeks, I think 47 FTEs. Each judge has 2 lawyers, one of whom is a staff attorney, the other is what we call a briefing attorney or a law clerk who's there fresh out of law school for 1 year. What I've asked for in terms of additional staffing are 2 new lawyers, one who would function as a briefing attorney and the other is a staff attorney. We have not passed rules on our court in 2 decades or more. We need to get back to that business. One of those lawyers will function as a rules attorney and coordinate on that issue. The other I intend to dispatch as a opinions proctor. We have challenges on my court getting opinions out. It's my personal view that no case should be pending in a terminal court for more than 1 year. We've had cases sitting for 4 years. When we have a chambers that's having that problem, I want another lawyer attached to my office in that chambers working on those draft opinions so we can get them out on a timely basis. But it's a little difficult to get angry at the judges when they're churning out the volume of work that they are. So another long-term issue, and I know I'm going to hear about this. We have those intermediate courts, and there's 15 of them now, which is 3 times the number of any other state in this country. And they have now developed substantial expertise in the area of criminal law. They do not handle writs. They could handle writs if we were to allow them to do it. And we could review those writs on a finding of probable cause of a basis for review to our court. That would help us substantially. That would remove us from 7,000 to probably 4,000 cases a year. Now, I don't know that they want to look at them, but somebody needs to look at them. And we're doing it now with very thin staffing. And on top of that, as you know, we have exclusive death penalty appellate jurisdiction. Those are very serious matters, and they take up substantial time. And again, reflecting what I will call the funding crisis that our judiciary is in, I will just tell you, I spent half of the day a week and a half ago with all this on my docket, bringing a court reporter in from one of our counties, threatening to jail her, and I may have to do that next week because we have a man sitting on death row right now who has a right to an appeal in my court, who cannot have his appeal heard because we cannot find out what the witnesses said or what the lawyers said at the trial because we can't get a transcript. It's the year 2025. The government knows what we're saying on our phones. Alexa knows what we've ordered, and I can't find out what the witness has said in a case where we have a man waiting to be executed. So these are pretty basic challenges that need to be addressed, and I'm just telling you, we need help on those things. And then last, for those of you from West Texas, we are also responsible for, and I sit on the board of the Texas Indigent Defense Foundation. Those people need lawyers, and we don't have them for them in West Texas. So we need to find a way to get people represented who are entitled to it. And with the challenges we have with attracting judicial talent, attracting lawyers to represent these people, we have a constitution, and it assures them a speedy trial. And if we can't get them lawyers, we can't try their cases. And at some point, we're going to have to say, your case is over because the state could not provide you with a lawyer. So anything that you could do to help, particularly in those areas, affected areas of West Texas, would be greatly appreciated. I commit myself to working with you or anyone else that would try to address these problems. But we have a big mandate. It's very important to us. We take it extremely seriously. My colleagues are working hard. They're committed. They're good people. But we have a big challenge in front of us, and so does everybody beneath us. And I think they deserve to be recognized for the hard work they put in. And in those rare cases where they are not putting in that work, we need to do something about it because the rest of us are suffering for it. With that, that's all I had prepared to say. If you have any questions, I'd be happy to address them.
Speaker Moody. The chair will show Representative Schofield present as well. Speaker Moody.
He's here. Judge, thank you so much. I appreciate your time and circling back with the committee. I just wanted to say thanks for mentioning the work on TIDC. I serve over there as an appointee from the House, and so I look forward to working with you over there. And as you well know, there are a lot of suggestions on how we could improve that situation out in West Texas that TIDC has brought forward this legislative session. Now, I know judges don't make it their practice to weigh in on things like that, but I think your perspective on that for the decision makers in the appropriations world and others that are going to be kind of figuring out where we land on some of those decisions, I think it would be very helpful. So if those folks are not having conversations with the court or with you, then I would encourage them to, because I think your perspective on that would be very helpful. So,
Well, I appreciate that. And it's not just me. I'm sure it's the whole court. We have regional appellate courts out there who are also committed to addressing these problems, and administrative judges. But it is a problem. And we have, I believe, a public defender's office in parts of West who do excellent work. We could expand that. But getting somebody competent and motivated to represent these people is
well,
pretty basic.
And that's why TIDC got real creative in looking at different pipeline projects and more strategies to build that workforce up, because it's not something you're going to be able to fix overnight, but you have to put the pieces in place. So I appreciate your advocacy on that point, because I think it's incredibly important to make sure that justice.
Well, I think we may have to think creatively. We hand out hunting licenses in this state. We have lots of tall building lawyers in Washington, in Dallas and Houston. Give them the chance to hunt in Aoudad in West Texas, and maybe they'll handle a couple of cases.
See, I like it. All right, we're going to go some creative solutions, Judge. I appreciate your time.
Yes, Representative Schofield.
Judge, it's great to see you. I know we've known each other a long time, and I know that you've seen state government from a lot of different perches, and I'm glad that you'll be bringing some of that expertise to your current position. A couple of the things you said reminded me of some of those things. Now, you told us here that you need a rules attorney, and you don't have one, right? I know the Supreme Court's had one for at least a quarter century, because
Correct.
I got my job in the governor's office where I worked with you, because the person who had my job took the job as the rules attorney. So they've had one for a long, long time, and your rules you may not cover all the areas of the world that the Supreme Court does, but in the area you cover, you're it. And everybody with any criminal case is dependent on what you're determining.
I think the challenge there has been that as the case volume expands, the first crisis is, today's crisis is the only crisis, and the rules are something that can be pushed down. We do not have a rule on recusal, right? We do not have a rule on setting up Chinese walls or screening judges who are recused from cases. We need those things, and I really would like to address those. I fear, though, again, that the volume will kick back up, and we have been running a much leaner operation. You'll see in my request for my extraordinary item request. I have one assistant to the clerk. I believe my clerk is working with a third of the staff that our colleagues across the hall are working with. So we're lean, we're efficient, but at some point the seams start to fray, and I fear that we are there. So I'm just begging you, judicial salaries for the trial judges, and particularly in those big counties, we have got to attract the kind of people. I mean, you know, I mean, in Harris County, we're terminating people's parental rights, we're sentencing them to death, and the person they're standing in front of, the public-facing element of the state government, is effectively the lowest bidder in the bar, and that's a problem, and it's showing itself. And I saw that on the Conduct Commission, and you probably saw, we were dealing with judges in your county that were shackling lawyers to the benches, that were turning loose people out of the jails. It's not acceptable, and the public expects better, and I think from all of us, we are obligated to give them better. So it's just very hard to attract them without, some reason for them to come. And I would really appreciate it if you could work with the Conduct Commission and the people that are trying to address that, to get it in a position where it can protect all of us.
And Judge, one of the other things you mentioned that I think was important was the workload in terms of the writs. Now, there's very little likelihood we're going to create more judges at your level. And the U.S. Supreme Court operates with 9, but over the years, as we've gotten to 30 million people and they've gotten to 330 million, a support structure has developed underneath to handle the intake of all those matters. The solution that you recommended here today was for the Court of Appeals to do it. I remember back in the day, and maybe it's gotten better, but we used to, when I worked for Governor Perry, we tried like the dickens to get at least one person on each appellate court who had some criminal background. And particularly in the 3-judge courts, it just was impossible. But even in Houston, we had to squint and claim Eva Guzman to be criminal because she did family law and her husband was a cop. So we may have to look into whether the appellate courts have the sufficient criminal background to handle this very important work that you're talking about.
I have every confidence, even on those 3-judge courts, that we have very bright people. The federal district judge cannot be either. If you're asking for one or the other, most federal district courts are people that were in civil practice or criminal practice, and yet somehow they all manage a docket that has federal and state habeas and breach of contract, constitutional disputes. I think I'll help train them. If they need it, I'll help them.
Thank you, Judge. I appreciate your service.
Yeah, Vice Chair Hayes.
Thank you. Thank you for coming today. I appreciate your comments on judicial pay. I agree with you. Can you make a recommendation to our committee? You said 15% was what it was not enough, it was inadequate. I totally agree. What do you recommend?
Careful here.
You,
Say 30 or more.
yeah, I think at least 30. I put it this way to the Senate. Look, you have friends that are federal magistrate judges. They're not allowed to try a slip and fall case in a grocery store without the consent of both sides of the docket, because we don't trust them, because they're not senior enough to try those cases. They are currently paid, I believe, $70,000 more than myself and my counterpart, the Chief Justice on the Texas Supreme Court. Why do we want worse judges than the federal system has? You could peg it to the federal system, or you could at least follow the recommendation of your own commission on judicial pay and just go with the 30%. But again, I'm no longer on that Conduct Commission. I can sanction people as hard, and I've shown I can do that. But it's kind of like showing up at the fire department to look at the chimney and the smoldering ashes after the fact. There's not much you can do about it other than say that this shouldn't have happened. But putting people on these benches that shouldn't be there in the first place can't be fixed other than by drastic measures like that. And the fact is, I'm sorry, but we have a few of them. And right now, the Conduct Commission can't do anything about it because we have a special court of review over them that has made it impossible to enforce those canons. So, and it's kind of ironic because there's 2 provisions of our Constitution that make it mandatory for a judge to be impeached by you if they're habitually not showing up and doing the job. So I think 30% would be my answer for this session.
Thank you.
Members, other questions? Okay, thank you.
Thank you.
We look forward to working with you. This has been very, very helpful, and we've got some work to do, and look forward to working with you on it. Members, other
thank you all
questions?
very
Okay,
much.
thank you. All right, the chair lays out House Bill 865 by Speaker Moody, and then after this, we're going to go to House Bill 748. Chair lays out House Bill 865 by Speaker Moody and recognizes Speaker Moody to explain the bill.
Mr. Chairman, would you mind if I present the bill from here?
Not at all.
Mr. Chairman, members, thank you for hearing House Bill 865. This is a bill that limits civil liability, which I'm sure is not something you'll see me doing most days in this committee. But it's a simple bill that really is just common sense. There are a lot of situations where a person might need to temporarily give up their weapons, their guns. It might be voluntary choice. Let's say if they're going through a mental health issue, or they decide they don't need to be around a gun until they're in a better headspace. Sometimes it may be involuntarily when a court has ordered them not to possess a firearm. But either way, how do they functionally do that? So one of the ways they can do that is to have a federal firearms licensee to store those weapons for a fee. And that's what's done in some other states. And it's proven very effective. One reason we don't do it here in Texas is because of potential liability. When an FFL gives that person their guns back and a tragedy happens, there is a fear that the FFL will be sued based on the idea that they should not have returned the firearms. So what HB 865 does is preventing that from ever becoming an issue. It shields an FFL from liability when they return a firearm to its owner as part of a firearm hold agreement. It's not unlimited. You have very standard language that says if the FFL acts unlawfully or with gross negligence, then they're not afforded that same protection. So if the FFL returns the firearm to someone who they know is not a lawful possessor, for example, they're not going to be able to take advantage of that shield. But if they're acting lawfully, then they don't have to worry about the lawsuit for returning that firearm. What I hope that the bill will do is encourage these kinds of agreements. They help with public safety when we're talking about people getting into compliance with certain court orders. They're good for personal safety when we're talking about mental health, especially among our veteran population, who often recognize that they're going through something, but sometimes make an irreversible choice before they can get the help they need, simply because how easily accessible a gun is to them. And this bill, quite frankly, is good for business for the FFLs. If they want to offer this service to their customers and they're worried about the risk, this would solve that problem. I'm happy to answer any questions, Mr. Chairman.
Thank you, Speaker Moody. Members, any questions for the bill author? Okay, you've got a few witnesses who want to testify. The chair's gonna, there's 4 witnesses. I'm gonna call all of you at the same time, sit in the 4 chairs in front of us. The chair calls Gary Zimmerman, Abby Kamen, sorry. Wesley Lewis, and Mitch Fuller. City Council member, say it again.
City Council Member Abby Kamen, like
Abby
you came
Kamen.
into the room.
Okay, got it. I've got you here on behalf of the Houston City Council District C and yourself testifying for House Bill 865.
Yes,
Is that
sir.
correct?
Yes, sir.
Okay, and we're going to limit witness testimony today to 3 minutes. Of course, that's at the chair and the member's discretion to go back and forth with questions. But I'm going to put a timer in front of you. If y'all will just try to keep it to 3 minutes, it would be appreciated by the committee. Go ahead.
Thank you. Again, I'm Abby Kamen, Houston City Council member and attorney, and I have led local efforts for firearms safety initiatives for our community in partnership with law enforcement, veterans organizations, health professionals, and others. And I am here in support of HB 865, which, as you heard, clarifies current code to ensure that there are liability protections for federal firearms licensees stepping up to save the lives of our veterans and active military members. Thank you, Chairman, Vice Chair, and committee members for your time. Rep. Moody, I appreciate your leadership on this issue. And I thank those of you, including Representative LaHood, for your family's long history of service. Texas has one of, if not the largest veterans population in the nation. And for those in our Harris County delegation, our county alone has the 4th highest population in the country. And I cannot begin to understand all that they have been through and sacrificed for us, but I do know that we must do better when it comes to supporting our veterans when they return home. There is an undeniable and tragic nexus between suicide, firearms, and our veterans. From 2003 to 2022, nearly 87,000 veterans died by gun suicide. That is 16 times, again, 16 times the number of service members killed in action over the same period. And Texas is higher than the national average. Rep. Dyson, HHS reported that MHMR Authority of Brazos Valley saw a 14% increase in suicide deaths from 2000 to 2020. And these, of course, aren't just numbers. As I've worked on this, I was shocked at how many people I knew had lost loved ones around this very issue. Veterans are more likely to use a firearm in an attempt, and we also know a firearm makes it overwhelmingly more lethal. But there are proven ways to help, as you heard from Rep. Moody. In addition to providing critical mental health services, we know putting time and distance between someone in distress and a firearm can save their life. And that's what secure temporary storage does, or firearm hold agreements. These are programs where a safe partner that veterans trust, like a shooting range, can provide a secure storage option where veterans can voluntarily, that's important, voluntarily store their firearm temporarily if and when they're in need. And this isn't just for those in mental health crisis. We've heard from retailers directly about families of loved ones who want to safely store their gun when children may be present in their home or when they're traveling. What is being proposed, I will add, has support across the board. Similar to Representative Moody, you will not normally hear me talk about increasing liability shields, but this is one of those, I think, where we can all agree. We have willing partners. Over 300 firearms licensees across the state have said they want to help, but the most common reason is they have these liability concerns. So again, this legislation provides clarification under Chapter 128 of Texas CPRC to ensure places veterans are likely to turn to are protected when these businesses are stepping up to help in a responsible way. And if passed, this gives us a real chance to help our veterans and our communities, reducing firearm theft, injuries, and deaths. Thank you.
Thank you, Councilmember. The reason I struggled with your name is because your name is spelled wrong in the record.
Okay.
Y'all were saying Cayman, and it's spelled Kamich. And so it's spelled K-A-M-I-J.
K-A-M-I-N, and I know Cassidy has a hard job and has to make sure that it's
So do I have your permission? That's okay. Do I have your permission to change it on the record?
Yes, sir.
K-A-M-I-N. Okay. Members, any questions for Councilmember Kamen? Yeah, Vice Chair Johnson.
Thank you, Councilwoman. Thank you very much for coming to Austin. Know that you are doing a lot on City Council and have been the chair of the Homeland Security Committee and have not only addressed the issue of public safety with regard to crime, but this seems just like a completely different issue that is really about protecting veterans and people in mental health crisis. Can you tell us who all of you worked with in trying to get some of these resolutions done, and how much do you think it'll benefit the City of Houston?
No, thank you for the question. There are, like I said, across the board, people coming together, organizations coming together to work on this very issue to save veterans' lives. I have to recognize even Commissioner Adrian Garcia for his efforts and his support on this. Of course, the City of Houston, the Mayor's Office of Veteran and Military Affairs, and Dr. Jones has personal experience with this. She has submitted very personal testimony to you all on this. Houston Police Department has been instrumental. The Harris County Veterans Services Department, and they have a program called Texas Two-Step. Again, a similar concept, but again, we struggle with finding those partners that are willing to, they want to, but because of the gray area of liability right now, they can't take that additional step and say yes. UT Health, Rice University Baker Institute of Public Policy, the Michael E. DeBakey Veteran Affairs Med Center, PTSD Foundation of America, and Camp Hope, and a member of Camp Hope that works in this space also submitted very tragic testimony, his personal experience going through this and what he believes would have saved his father's life had this been available to them. Partners like Target Safety. The list goes on, but I think what's clear is that everyone is coming together to work to save veterans' lives and do this the right way. And I could not do this without the type of support that we have, and we appreciate y'all's support as well.
Well, thank you for being such a strong advocate for our veterans in the city of Houston. Really appreciate you coming up.
Thank you, ma'am.
Thank you. Members, any other questions for this witness? All right, thank you. Chair calls Gary Zimmerman. Is Mr. Zimmerman here? Okay, seeing not, I will show him registering for the bill but wishing not to testify. The chair calls Wesley Lewis. Mr. Lewis, I have you here on behalf of yourself, registered for the bill. Is that correct?
That's correct.
All right, go ahead.
My name is Wesley Scott Lewis. I am speaking on behalf of myself in support of HB 865. I've been involved with the fight for Texas gun rights for 18 years now. I was a founding board member of Students for Concealed Carry. I worked for that group for 10 years, including as their legislative director for the state of Texas. Since leaving that group in 2017, I just make it a point to show up here when I see good legislation that needs some support, and honestly, this feels like a no-brainer. This feels like something that should be sent to local and consent. I think one thing that's really important to keep in mind is that without this type of protection for FFLs, what ends up happening a lot of times is if somebody needs to get the guns out of the house, they end up in a buddy's garage or in a relative's closet where they're not stored securely and they're not stored safely. So you run a risk of those guns being stolen, and you run a risk of a kid or somebody who shouldn't access those guns getting hold of them. So this really is the safest way to deal with this if somebody needs to get the guns out of the house. And there are, as has been explained, there are a variety of reasons why you might need to get the guns out of the house. It could be that the person is experiencing mental health issues. It could be that they're going through a divorce and that there's a mutual no contact order, which, you know, under federal law requires that person not to possess firearms while that order is in effect. They need somewhere safe and secure to go with the guns, and this is the most obvious way to do it. These FFLs typically have gun vaults. They have a way to store these guns safely and securely, and so I strongly urge passage. I really feel like this should be a unanimous vote for local and consent. Thank you.
Okay, thank you. Members, questions for Mr. Lewis?
I just wanted to say that I support his recommendation that this go to the local and consent count.
Okay. Members, any other questions? Your support for that is noted. The chair calls Mitch Fuller. Mr. Fuller, I have you here on behalf of yourself and the VFW Department of Texas, registered for the bill. Is that correct?
That's correct,
All
Mr.
right,
Chairman.
go ahead.
My name is Mitch Fuller. I'm the Legislative Director for the VFW Department of Texas, and for this VFW year, I am the Chairman of the National Legislative Committee for the entire VFW. So, Speaker Moody, thank you so much for introducing this bill. I concur here with my fellow witnesses up here and council member. I have the illustrious title of former city council member in Cedar Park, which is a suburb of Austin, so I understand what you do. And I want to thank our mutual friend, LaShondra Jones, for reaching out to me. Dr. Jones is a Marine veteran. There are a lot of ways to address veteran suicide, which is an absolute epidemic in our community. One of those, and I want to put you guys on notice right now, our top legislative priority is to oppose Senate Bill 3, which is probably going to be voted out of the Senate today. And that is, that's going to ban all THC.
We got to keep it on this bill,
Gotcha.
please. Thank
Gotcha.
you.
I have PTSD. That's part of my disability rating through the VA system. And in my mental health counseling with the VA, they address what's called a safety plan. They ask you if you have a firearm, and I do. This is a serious issue, and I'd like to go one step further, Speaker Moody. We are interested, the VFW, in participating in this. It's already kind of happening informally with VFW posts. So veterans are frankly more comfortable talking to fellow veterans. And so we know of VFW posts who are already doing this. We would be interested in a committee substitute in adding us to the language here, potentially. Congressionally chartered veterans organizations. There's a lot of veterans organizations out there. The VFW is congressionally chartered, like the American Legion. There's others that are congressionally chartered. We've been congressionally chartered since 1936. So I'd love to work with you on that, Speaker Moody, to address this. And Councilmember, you're right. Veterans, when they choose to commit suicide, they choose a lethal means to do it, and a firearm, unfortunately, is the choice that's referred to. So I appreciate you being here. Thank you.
Thank you, Mr. Fuller. Speaker Moody.
Yeah, I just touched base with my office so we can get the suggested language that
will.
you've got.
Absolutely.
Thank you very much. I
Thank you.
appreciate your service and your time here.
Thank you.
Members, any questions? Okay, thanks to each of you
Thank you,
for
Mr.
your
Chairman.
time
Thank
and
you.
your testimony this morning. Does anyone else wish to testify on, for, or against House Bill 865? Seeing none, the chair recognizes Speaker Moody to close on the bill.
Thank you, Mr. Chairman. I close, unless there's questions.
Okay, members, any questions for Speaker Moody? Okay, good bill. Thank you, Speaker Moody. We'll leave House Bill 865 pending at this time.
I just need to talk to my kiddos real quick. I'm handing back right now. No, but we are gonna vote this bill out after we hear. What, 7 minutes? Yeah, I'm okay.
Give me just a sec. Members, the chair lays out House Bill 748. There is a committee substitute. The chair lays out the committee substitute to House Bill 748. Members, I'm honored to present this important bill before the committee this morning, House Bill 748, which we're naming Trey's Law. You're going to get to know Trey and his story from his sister Elizabeth here in just a few minutes. Members, this bill is meant to address what I believe is a major problem under current law. Under current law, there is no specific provision that explicitly prohibits the use of non-disclosure agreements or similar confidentiality agreements and clauses as part of a civil suit settlement agreement with victims of sexual abuse. And as a result, many victims feel trapped, silenced, and feel like justice was never truly served. By allowing these type of agreements, often horrific and systemic abuse is hidden from the public eye, resulting in few consequences for the perpetrators, and often allowing for more people to be harmed by unknowingly interacting with a bad actor who's hidden behind a non-disclosure agreement. The committee substitute to House Bill 748 is very simple. It explicitly prohibits these type of agreements and civil settlement agreements, rendering them void and unenforceable under Texas law, to the extent that they would prevent a victim from speaking out about an act of sexual abuse or any facts related to those acts to any person or third party. The bill does, in its current form, allow for an agreement of the parties to keep other details or terms of a settlement, such as the amount or the payment terms, confidential. The substitute before you broadens the applicability of the legislation by defining, quote, an act of sexual abuse, close quote, to include not only all aspects of childhood sexual abuse, but also sexual assault, aggravated sexual assault, and human trafficking violations, regardless of the age of the victim. And of course, as I just mentioned, the substitute also officially names this act Trey's Law. Members, we have some incredible witnesses here with us today, some of the most courageous, bravest individuals I've ever had the blessing of knowing, and we welcome them to their Texas Capitol today to share their stories. The bottom line is, members, we, all of us, this legislature, we have a duty to protect victims. No victim who chooses to tell their story or to speak out about their experience should ever be silenced. We have, over the years, over the past few sessions, done a lot of really great work standing with survivors and with victims, victors, as I like to call them, and against their perpetrators. And to me, it's clear, you either stand with victims or you stand with the people who've harmed them. There is no middle ground. So it's time for Texans to pick a side. And as for me and this committee, and I believe this legislature, we are going to boldly and firmly and strongly stand with victims. And doing away with non-disclosure agreements in the state of Texas once and for all, making it against the public policy of this state to ever enter into one, I believe is the next step forward in this important fight. I want to thank, of course, the witnesses who we're looking forward to hearing from today. Vice Chair Johnson has been so wonderful and courageous in this fight. Other legislators have as well, including our colleague Representative Mitch Little, who's joining us on the dais today. Vice Chair Johnson and Representative Little's and others' fingerprints are all over this bill. And this has been strategically and very thoughtfully written and drafted. And I want to ask Vice Chair Johnson and then Representative Little to share a few words with the committee.
Thank you, Chairman. I also want to thank you for your leadership on this issue over the past few cycles. You have been brave and courageous to let everybody know how personal this is to you and your family, and I thank you very much for your leadership. I will say to those that are here, it's been a long time coming. And I, for one, am honored that we will have an opportunity to hear from you. And I know that as we hear from you, that the video, audio waves are going to reach thousands of survivors who have not had the courage and have not had the strength to sit up here. And with each of you, they are going to see a glimmer of hope. And with each of you, the state of Texas is going to know what we've done wrong and what you need from us to be better, to be more, and to ensure that what has happened to you and your family and your friends is truly something of the past. And so thank you for your courageousness, your vulnerability, and we are grateful to be able to have an opportunity to hear you today. Chairman?
Thank you.
And
Thank
that's
you, Vice
because
Chair
of you.
Johnson. Thank you.
Thank you.
It's an honor to work with you on this. Representative Little, it's great to have you on the dais today and your role as a legislator and as a skilled attorney, and would love to have you share some words with the committee.
Thank you, Chairman Leach. It is extremely generous of you and your committee to invite me here today. I've had the pleasure of working with you on this bill. You've been very receptive and kind in considering potential amendments to the bill, and I think your committee sub does a very good job of laying out and addressing the problem. I want to just provide briefly the perspective of a practitioner who has worked on child sex abuse cases involving churches, summer camps, schools, ministries. I've been in the room when these cases have been settled. Some of the child sex abuse cases I've worked on have been horrific. One involving a 12-year-old girl at our church summer camp who was molested by a pastor. And oftentimes the victim of sexual abuse at the hands of a pastor, family friend, a teacher is in a mediation room, and they're faced with the decision of whether to settle their case to receive some sum of money that is going to help them with their lifetime of therapy and counseling, to help them heal, to compensate them for the soul murder, which is really what sex abuse is, of having undergone that. And typically a condition that is presented by defendants in cases like these is a non-disclosure or confidentiality agreement so that victim can really never share their story outside of either a law enforcement context or under a subpoena when compelled to do so. I think we as a state need to decide that those types of agreements are void as against public policy. And I will cite to you a pretty significant example. So we're joined, I saw in the gallery this morning, Robert Downan's here. Robert Downan wrote a piece for the Houston Chronicle about the Southern Baptist Convention and the, I'll call it, prolific environment of abuse that exists not only in the Southern Baptist Convention, but throughout other denominations as well. And one of the reasons that it exists so pervasively is the culture of silence that really surrounds the issue. It's you hire a bad employee, they do something horrible, oh no, that's terrible, let's settle the claim, there's a non-disclosure agreement, and then pastor, teacher, volunteer moves on to another church and they continue their acts of abuse. So the incomplete flow of information in our society about who the abusers are and what they have done in some ways perpetuates the abuse against people throughout, not only throughout Texas, but through other parts of the country as well. And so when I've been in those rooms with plaintiffs and I've been presented with those non-disclosure agreements, I've said, we're not going to sign it. And we'll agree to keep the terms of our settlement confidential, or how much you paid, or however you want to pay. We'll keep that confidential. But I want to empower my client to be able to tell his or her story as they become adults so that they can heal, and so that other people don't suffer the same fate at the hands of the same people. I understand Ms. Clemishire is here to testify as well about what she endured at the hands of Robert Morris, who I saw was just recently taken into custody yesterday or the day before. I am here to tell you that I know for a fact that in large organizations like churches and parachurch ministries, schools, summer camps, oftentimes the board of directors or board of trustees or board of elders is aware of the abuse and participates in concealing it. And I think we as a legislature need to decide that we're not going to aid in the concealment of that information. Oftentimes, as a lawyer, it's very easy for me to say, well, I'll negotiate my way out of it. But not everyone has a lawyer. Not everyone can negotiate their way out of it. And, you know, I can remember times where I was sitting in court or mediation going, well, I don't get to make those decisions about what's void as against public policy. Well, now I do. And the rest of us do as well. And so I thank you for your generosity, Chairman Leach, in allowing me to participate, and I look forward to hearing what these fine citizens have to say. Thank you.
Thank you, Representative Little. Well said. And it's not generosity. Your input and expertise is invaluable, and you're welcome here at this committee on this bill or any others going forward, and appreciate your thoughts this morning. And you know what is happening with these NDAs? It is truly a re-traumatization of a victim when you tell them that they cannot tell their story, when under the threat of them losing whatever settlement or whatever care has been promised to them, they are unable to talk about what happened to them. It is truly, in many cases, just as traumatic as the original abuse itself. And we're going to, I'm very confident, pass this law this session and make it, as you said, Representative Little, against the public policy of this state to even request an NDA. And so with that, members, I'm happy to take questions if you have any. If not, let's get to our witnesses. The chair calls Cindy Clemshire, Elizabeth Phillips, Catherine Robb. Let's start with the three of you. Good morning. It's great to see you again. Welcome back to the Capitol. And the committee looks forward to hearing from you this morning. Elizabeth, let's start with you, and then we'll go to Cindy and then Catherine. Is that okay? Okay. The chair recognizes Elizabeth Phillips. I have you here testifying on behalf of yourself for House Bill 748. Is that correct?
Yes, Mr. Chairman.
All right, go ahead.
As you said, I'm Elizabeth Phillips. I'm from Dallas, Texas, District 108, where I grew up and where I still live today. Thank you to this committee, and a special thank you to Chairman Leach for authoring this bill to prohibit the misuse of NDAs against child sexual abuse and trafficking victims, and for naming it after my late brother, Trey Carlock. It honors him and my family, our loss, and the countless survivors of child sexual abuse like him who didn't survive. I'm going to read my testimony because this has been a long time coming. I've been working towards this day for 5 years, and I want to get through my testimony in the allotted time. Thank you.
Time limit doesn't apply to this bill.
Thank you.
Take your time.
Trey was my little brother who was silenced to his grave by Kanakuk Ministries, a summer camp and global enterprise based in Southwest Missouri. Trey endured a decade of grooming and child sexual abuse by their popular director, Pete Newman, followed by a re-traumatizing civil litigation process that ended with a restrictive NDA. Sadly, a lot of truth dies with people because of NDAs, and that only protects bad actors, which is contrary to public interest. To me, that is the point of Trey's Law and this hearing today: public safety, protecting children. I've actually learned more about the extent of my brother's abuse in his death than I knew in his life due to the NDA he was under. Trey told a therapist, "They will always control me and I'll never be free," before he died by suicide in August 2019. He hesitated even to tell his story in confidential therapeutic settings for fear that Kanakuk would come after him again like they did an earlier John Doe. Now that I know what I know and have caught my breath, I'm trying to be a voice for Trey and the countless other victims of childhood crimes who are suffering in the shadows due to NDAs that restrict them from speaking in settings like this. Since my family was public about Trey's Kanakuk camp's abuse in his Dallas Morning News obituary, we've heard from so many other victim families with similar stories. 17 suicides and lives wrecked beyond belief all over the world. Kanakuk survivors assembled an advocacy website called Facts About Kanakuk, which launched in 2021 and has since received continuous tips with hundreds of abuse allegations against more than 65 unique perpetrators associated with Kanakuk, dating from 1958 to today. Texas is one of Kanakuk's largest markets. The same family that has been at the helm of Kanakuk throughout these decades. While victims have been lawfully hushed by NDAs, Kanakuk and its insurers demanded, behind closed doors, with attorneys who would gaslight and intimidate victims in depositions that led my brother to a psychotic break. My brother had many layers to his journey of injustice. First, he was groomed and abused from age 7 to 17 by a serial sex offender who was sentenced to 3 life terms in 2010. Trey was 20 years old when Pete went to prison. Then Trey was forced by the civil statute of limitations in Texas to file his civil case against Kanakuk before the age of 23, while he was just trying to finish college and also process unimaginable trauma amidst a Christian culture applauding Kanakuk and hailing its CEO, Joe White, as a spiritual hero. Trey's civil case ended with a settlement that included a restrictive NDA, making Kanakuk and its representatives another perpetrator of abuse in Trey's tragic and unnecessary demise. Institutional abuse on top of sexual abuse. I've seen firsthand how NDAs and child sexual abuse settlements conceal decades of abuse for the sake of personal and institutional protection. Until very recently, when some brave survivors broke their NDAs to speak with investigative journalists, dozens of Kanakuk victims believed that they were the only ones who had been abused there because the story barely reached the media. I've spoken with many men and women who spent 20 plus years believing that they were the only child abused at that summer camp or one of its affiliated entities. An Oklahoma woman in her 70s who was sexually assaulted the very first year Kanakuk opened its doors to girls shared her story of feeling crazy her entire life until she stumbled upon an article about 3 years ago that exposed the evils of Kanakuk. I was the first person she'd ever told, besides her husband. Delayed disclosure is normal for victims of child sexual abuse, if they ever disclose at all. So, when the floodgates opened and survivors coalesced around a petition asking Kanakuk to release victims from their NDAs, we garnered nearly 30,000 signatures. Kanakuk's response was a public statement and blatant lie that they do not use NDAs. Those of us who knew better called that out, so then they said they do use NDAs, but it's only at the request of the victims. Survivors called out that lie, and Kanakuk changed their tune again, admitting in an open letter from CEO and board chair Joe White that they do use NDAs, but it's their insurance company that makes them do it. And in order to avoid repercussions, victims should not disclose their settlement terms. Kanakuk won't come clean, and we're not giving them any more chances. We're going to change the law. The law on NDAs must be clarified because we cannot trust institutions to do the right thing. It's no exaggeration for me to claim this as a matter of life and death. I think we know what child sexual abuse does to a person's life, does to a kid. And I think we also know how healing happens. It's by sharing your story in safe places, finding support and solidarity. That's the whole basis of talk therapy and the Alcoholics Anonymous model, for example. When you take someone's voice away, especially a child's, you take away their most linear path to healing. Trey's law should be a welcomed and minimum measure of justice so that future victims of childhood crimes do not have my brother's outcome. There's a quote that says, "Shame dies when stories are told in safe places." Tennessee made itself safer in 2018 when they became the first U.S. state to pass a bill prohibiting NDAs in civil child sexual abuse settlements. And 18 states, along with U.S. Congress, have clarified the NDA issue for adult survivors of sexual assault. It's time we do the same for children, and Texas can be a leader on this. NDAs are for trade secrets, not trauma secrets. I get asked a lot since becoming more public about this issue on a national level. Why would your brother sign an NDA? Was he physically forced? Well, actually, when you've been abused and gaslighted and re-traumatized by intimidating lawyers on both sides who want to close a case, you're exhausted just trying to function. And then opposing counsel offers you 7 figures if you just sign on the dotted line. You need to be able to pay for treatment and a lifetime of care. You want to move on and hopefully heal. So you accept the payout, but it feels like a bribe. My brother referred to his settlement as blood money, as if he had betrayed his own soul to keep Kanakuk's secrets, and it killed him. So, I'm here before this committee to ask you to please remember Trey. I'm asking the Texas legislature to pass Trey's law this session as an urgent matter of public safety. I'm proud to be Trey's sister, and I hope Texas will be proud of Trey's law. Thank you, and I'm prepared to take questions.
Thank you, Elizabeth. Members, any questions? Yeah. The chair calls Cindy Clemshire. Cindy, I have you here registered on behalf of yourself, testifying for House Bill 748. Is that correct?
That's correct.
Welcome back in front of our committee and to the Capitol.
Thank you.
Go ahead.
Thank you for having me back again. I don't know that any of us really need to say anything after that, but thank you for taking the time to hear my story. I've jotted down a few things and trying to stay on track with this.
Take your time.
Okay. As you already know, I am Cindy Clemshire. I'm from Oklahoma. I grew up in a small town, Hominy, in Osage County. I am a survivor of child sexual abuse that occurred, that occurred between 1982 and 1987 when I was 12 to 17 years old. I was abused by Robert Morris, then a traveling evangelist who was married with 1 child, who went on to become the founding pastor of Gateway Church, one of the largest mega churches in America here in Texas. As I stated, the abuse started when I was 12 years old on Christmas night in 1982 while Robert Morris was staying in my family's home. The first time he made the premeditated decision to violate and defile my purity, he told me, and I quote, "You can never tell anyone because it will ruin everything." This abuse continued over and over and over until I finally told someone in 1987 at the age of 17. When I did finally tell someone, it seemed as though Robert Morris was right. It ruined everything. Friendships ended. Marriages of mutual family friends ended. My relationships with my parents, my siblings, friends, and others took a shift. And at 17 years old in 1987, I felt like as if it was all my fault. As I began As I began the lifelong journey to sort through these emotional challenges, my life seemed to attract more shame, while Robert's attracted fame. Through decades of counseling off and on, seminars, books, and conversations with friends and family, I have found my way to understanding child sexual abuse, forgiveness, and healing. Part of that journey also involved a pursuit of financial restitution from Robert in 2007 at the age of 37, 20 years after I first told someone. My attorney at the time, Gittner Drummond, who is now the AG of Oklahoma, asked for $50,000 to cover past and future counseling. Robert Morris's attorney responded with a letter accusing an innocent 12-year-old Cindy of pursuing Robert, making Robert sound like the victim. The letter also offered a $25,000 settlement as long as I would sign an NDA, which I refused. That was 18 years ago. Because I refused to sign that document giving up the right to freely speak about events in my life, last Wednesday, March 12th of 2025, almost 43 years after my abuse began, Robert Morris was indicted in Oklahoma on 5 counts of lewd acts with a child, which each carry 20 years in prison. And he turned himself in to authorities just 2 days ago in Osage County in Oklahoma. Because I refused to sign an NDA, my abuser is finally being held accountable for the horrific crimes he committed against me as a child. Because I refused to sign the NDA at the age of 37, I am able to sit here at the age of 55 and share my story and be the voice for so many people who don't have the courage to come forward in hopes that I can help them.
Cindy, thank you. Chair calls Catherine Robb. Catherine, I have you here on behalf of yourself and the Children's Justice Campaign testifying for House Bill 748. Is that correct?
That is correct.
Okay.
Thank you for hearing my testimony today. I am the National Director of the Children's Justice Campaign. I have testified in over 35 states for any type of child protection legislation. But I'm also here as a survivor. I was abused by a family member starting when I was about age 7, and it ended when I was about 14.
Thank you.
So I do bring the voice of a survivor to all of, all of my testimonies across the country. And I understand, not just based on the research and the data that I testify on, but I understand anecdotally and I understand personally that when victims are sexually abused as children, as we know the data tells us, that it takes years, decades, if not a lifetime, to come forward because they are silenced. They are silenced by shame and fear and intimidation and threats. So to allow victims, when they finally come forward, to have a voice, to again silence them in protecting bad actors and institutions, to me, is simply outrageous. I speak to survivors all over the country and all over the world. Almost 100 a month I speak to survivors. But what's most painful is when I get calls from family members telling the story that Elizabeth just shared here about the loss of a family member who could no longer bear the burden and the pain of keeping this secret, and then again to be tied up in an NDA. And I want to make it clear to this committee that yes, survivors like myself and those that have spoken here, it's important for our healing that our voice is not once again snatched from us. It's important for our healing. It's important for other survivors to see that, yes, you can do this. You can come forward. But I'd say that almost equally important, if not more important, and I say this as a reasonable woman, not just as an attorney and an expert in this field, but also as a mother of 5 and a recent grandmother, that NDAs protect bad actors. They protect the perpetrator, right? Secrets don't help children, right? So I think of this in a forward way as well, not just that it's helping survivors have their voice and have their healing, but the children of Texas will be safer because these secrets are not covered up in an NDA. And as Elizabeth said earlier, these are not typical tort cases. These are not contract cases or slip and fall cases or trade secrets or confidential secrets in a business. That's not what we're talking about here. Let's be really clear. We are talking about covering up secrets about the rape of children, the sodomy of children, the sexual assault of children. And if we allow our bodies of leaders like you here to allow them to be covered up, then the children of Texas are no longer safe. Because I have never seen a secret that benefits a child. And it is time, and I thank you, Chairman Leach and Vice Chair Johnson, I thank you for supporting this legislation because it will indeed make the children of Texas safer. I'm happy to take any questions.
Thank you. Thanks to each of you for your courageous testimony. Vice Chair Johnson.
Thank you, Chairman. Thank y'all. I'm equally having this kind of overwhelming moment as I'm looking at the 3 of you as you testify. The heads are nodding in the background in the audience. And you can see that there's this relief that this conversation is beginning. But I'm also feeling some kind of way about the seal behind me and where we are here. And what is frustrating to me is that it seems that a contractual provision of an NDA has been used by individuals to protect their bottom line. And the complete opposite of see something, say something. And it is daunting that it has taken literally decades and generations of silence and suffering to finally get this conversation to the seal. And I want to thank you, Elizabeth, because many of us have a big sister. But I can't think of a stronger big sister or a more committed big sister or the greatest act of love that you have shown to Trey. And I'm sorry to ask this question, but I do want to ask. What has it been like for you? Because you mentioned you found out more about Trey after his passing than you did in his life. Tell us what it has meant to realize that your brother did not have the ability to come to his big sister because a bunch of lawyers or a bunch of organizations worried about their bottom line continued to silence the suffering from his family.
Thank you for the question, Vice Chair Johnson, and for your championship of this type of legislation over many sessions. It has been a very painful journey to come forward with my family's story, with Trey's story. However, if we can protect one child from Trey's suffering that I had a front row seat to, seeing him in and out of treatment centers where he was scared even in those settings to talk about his abuse. Late night phone calls about suicidality, addiction issues. He tried everything to heal, but ultimately was legally silenced to his grave. And now that I know what I know, this is an atrocious practice that's become a standard practice in personal injury law. And it's time to end it because we don't want anyone else to have Trey's outcome. And what I'll say is that today's opportunity to testify before this committee and to meet with legislators who actually care has given my family's pain some purpose. And I hope it doesn't end here. Thank you.
I can tell you personally, I think you were instrumental in some of the media outlets paying attention to some of the legislation that's been going on here. And months ago, back at home, somebody that I'd known for decades, and I never would have suspected, grabbed me by the arm and said, "Can I talk to you?" And he told me that he was a victim and had not yet dealt with the issue. And so everything that you are doing, every voice that you are lifting, you are creating that light at the end of the tunnel for people who have suffered in silence for decades.
That makes it all worth it. Thank you.
You're welcome. Ms. Clemshire, I had a chance to see you come speak at a SNAP conference almost a year ago now.
August of last year.
For those that didn't get to see it, you had this incredible visual of a piece of luggage, and it caught me in the way that you drug that luggage across the stage. And with that visual, can you tell the people that are listening to you today what you meant by carrying that luggage?
Yes, as I talked about just a few minutes ago, the shame that my life continued to attract, that was what I decided to use to show people. Like when I left home at 18 to go to college, I carried with me shame that I really couldn't even begin to understand. And as I journeyed through life, I just continued to fill that luggage, that suitcase with shame. You know, whether it was divorce, pregnancy out of wedlock. I often call myself one of the lucky ones because it wasn't a family member, it wasn't my father, and I didn't become addicted to drugs. You know, I had my other share of trouble and choices that I recently heard someone say many times, we know what someone's character is, but their choices aren't aligning with that, and it's very confusing. And that was validated when my story went public last summer, when my high school English teacher and speech teacher, who I'm still friends with today, she called me and she said, "I always wondered what had happened to you because your life took a path that none of us anticipated and didn't look like who we knew you to be and how you were raised." And that is what that luggage represented, was all the choices that didn't align with my character and who I am. Just more and more shame added to what was started when I was 12 years old.
And you're in a unique position because you hear about sexual abuse taking someone's innocence.
Yes.
Representative Little has talked about it. The abuse that the offender causes is absolutely criminal.
Yes.
But Representative Little also mentioned the fact that many times where it's coming from somebody out of an organization or an entity that has the ability to recruit vulnerable populations, especially kids.
Yes.
That entity and that organization needs to take those perpetrators equally seriously, or the manner in which they come in contact with them. You've also highlighted another significant point of what I'm almost going to call this evolution. You talked about You disclose facts at the age of 17. You again, at the age of 37, found some strength again to try to get into the court system, and now here you are in your early 50s. Can you explain to us, as a policy-making legislative body, about that roller coaster of evolution for victims and when they have the strength or ability to maybe come forward or not?
Yes, I think that that's exactly what it is, a roller coaster, because at 17, when I told, I did feel as though I was the one at fault, even to the extent that Robert Morris's wife, Debbie, called to tell me she forgave me. So still trying to
Just
mature.
let's clarify that. The wife forgave you for being a 12-year-old who
Yes.
her husband was having sex with, right?
Correct.
How did you take that? What did that do to you?
Well, at 17 and them being family friends, I was thankful because I felt like I would done something wrong. And I had been treated, though, as though I had done something wrong by Robert, like making me the guilty one or a part of something that I chose when I knew nothing. I mean, 82 was a very different time when we didn't carry computers around in our hands and we had 6 channels maybe on our televisions. So innocence was very different than it is now most of the time. But that journey from 17 to 37, it wasn't until, even with years of counseling, that I could accept the term abuse. I was 35, the first time I truly accepted and believed that he abused me, that it was criminal, and I understood what grooming was. And that changed the course of my journey to more healing, and there's anger, of course, involved in that. But I was having children. You know, I have 3 sons. They currently range from 17 to 32, and I also am a grandmother of 3. And I think that for a woman, I can only speak for myself and being a woman, but that journey involves protecting your children, and how you do that, and how much, I mean, feeling more shame if you talk about it publicly. We did privately go to people throughout the last however many decades, 3.5 decades, sharing with people in the pulpit in churches across the country about what he did to me and my family, in hopes that they would take him out of the pulpit, because we knew legally there was really nothing we could do at that, you know, the time of it. So it takes a lifetime, as Elizabeth said, to process and heal, but just to have the courage to come forward and speak openly to the world, I never would have been ready until now.
Thank you. This silence of shame, the structural manner in which it is put together, and we are here talking about the NDA today as a policy-making body, as part of an organization, as an individual victim. Can you give us a sense? What is the gravity of the problem in Texas, and how necessary is it for us as a public policy that people have the opportunity to tell these stories and, for lack of a better phrase, warn others about the perpetrators that are in this state?
Thank you for that question. Right now, we know in the most recent data that about 1 in 8 children will be sexually assaulted before they're 18. If that's not an epidemic, I don't know what is. It affects all children, regardless of their racial background, socioeconomic status, their political beliefs, whatever it may be. All children are affected. And I think the other thing that's really important to mention is that the burden of this epidemic is on Texas and the taxpayers, because these folks, myself included as a survivor, we need help. Now, I was lucky. I was a basketball junkie, and basketball literally saved my life. I can say that now that it's March Madness, right? But it literally saved my life. Not others are so lucky, right? But I needed help. You need social services. it burdens that system. It burdens the educational system because survivors, again, take this path, this sudden right or left turn, and have behavioral issues, educational issues, focus issues, memory issues, the whole neurobiological effect of trauma. I could go on that for a long time. So my point is that it burdens all the different systems of the state of Texas, and taxpayers are paying for this. It is about time that we shift the burden away from the state and taxpayers to the bad guys, right? And I think that the very nature of abuse silences the victims. Again, we're not talking about slip and fall cases. We're not talking about fender benders or anything like that. And this bill is narrow. This is for any opponents out there. This is a very narrow bill. This is just for child sexual abuse claims, right?
The committee sub expands that.
Yep.
The committee substitute does
That's
expand
right.
that to all
That's
cases.
right. I stand corrected. But still narrow, generally narrow. It's not saying all settlement cases, all confidential agreements. You know, it is your power and your, quite frankly, your wisdom, right, that will make the children of Texas safer, that will give voice and healing to survivors, because we're living in an epidemic. And most of these perpetrators, certainly everyone at this table, all of our experiences, is someone that the victim knows. For me, it was a family member, knows very well, right? So it's really hard to sort of parse out in terms of our systems that can help with this. This will make children safer, undoubtedly.
Yeah, thank you. I want to mention a couple things before we move on to our next panel of witnesses very, very quickly. I do think it's important to stop here and just to note, and hopefully all agree, that for victims that for whatever reason may not want to speak out, that may want to hold their story to themselves, we fully support that, and our law supports that, and there is no pressure or guilt or shame that should be felt by any of those victims whatsoever. But for those who feel now or going forward that they are silenced by any law on the books in the state of Texas, today we are going to drive a stake in the ground that says that is not the case, not anymore, not now, not going forward. So for those who want to speak out, this is a bill that empowers you. For those who choose not to, this bill empowers you as well. Secondly, Cindy, when I hear you talk about how Robert Morris so egregiously attempted to silence you, I'm reminded of a clip I saw of his from a sermon that was around the same time when he was trying to silence you, prevent you from telling your story in exchange for blood money. He was on the pulpit at Gateway talking about his past indiscretions, and communicating and telling the story to his congregation in a sermon from the pulpit about how he had an inappropriate relationship with a lady, making it sound like it was consensual, and that it was an impropriety, and that it was an affair from long ago. Then the letter that they came out with this past summer, where they said that he had been involved in, I don't remember the exact words, I don't have it in front of me, indiscretions with a quote, I think it was young lady. Didn't mention that you were 12. Let's all remember Cindy was 12 in 1982. 12. It's the same age my wife was when her abuse started. And so how horrifying that must have been. While he was attempting to silence you, he was telling his own story from the pulpit.
And
we're going to go on to our
people were
next
allowing
panel of
it.
witnesses, and we're up against the clock here. We're going to do something in a few minutes that we don't typically do around here, but except in remarkable and special circumstances. We're going to hear from our next panel of witnesses, and then before we go to the floor, Members, just so you have a heads up, we're going to vote this bill out of the committee and to send this bill to the House floor this morning. I think that it's important that we do so before we go to the House floor. And so thank you each for being here. I'm going to call our next panel of witnesses so we can make sure that we get done with our business before the floor. The chair calls Curtis Garrison, Christina Green, Jennifer Allman, and Joseph Cleveland.
Mr. Chairman.
Yes.
Chairman present.
Yes. Oh, the chair will show Chairman Dutton as present.
Could I ask a question?
Of course.
Right. If it's a continuous act, part of which occurs during the childhood and part of which occurs during the adulthood, does this affect that?
So this bill only affects, this bill is not relating to statutes of limitations. There are other bills
Right.
dealing with that. This bill
Right.
just affects an agreement whereby it would affect both. The original version of the bill only applied to childhood sexual abuse and assault. The bill now applies to all cases. So if an NDA has been entered into, it would be void as
applies to
against.
all cases now?
Correct.
Okay.
Correct.
All right, good, thank you.
Okay. I am going to put the timer back up. I apologize, but we do have to be sensitive to the clock. So the chair calls Joseph Cleveland. Joseph, I have you here on behalf of yourself, registered for the bill. Is that correct?
Yes, sir.
Go ahead.
Good morning, committee members. Thank you for letting me testify today. I'm going to read my testimony because it's easier. My name is Joseph Cleveland. I live in Huntsville, Texas. In 2004, at the age of 15, I was introduced to a man who was a pedophile. This was just after my parents got divorced and after growing up with a severely abusive father. At that time, I was desperate for any form of male leadership in my life. So needless to say, I was an easy victim for him. This man began grooming me and would eventually begin molesting me. This happened once or twice a month for the rest of my high school. Little did I know, this man was working alongside a college ministry called Chi Alpha within the Assemblies of God for at least 2 decades and had already molested other boys, for which he had served 90 days in an Alaska jail. Pastors in our ministry tried to convince students as I grew up to go to college, many of whom were also victims, to write letters of lenience on behalf of the abuser to the judge. And you would think after graduating high school and turning 18 that I would have moved on and left. After all, why would anybody continue to let themselves get abused as an adult? Unfortunately, that's not how grooming or the mind of a victim works, so I'm sad to say that the abuse continued. When I was abused in 2005, the statute of limitations in Texas was that I had until the age of 23 to come forward. At the age of 23, I was still being molested by this man. For a significant amount of time, the leadership in the Assemblies of God, which was the denomination that I was a part of, had been my whole life, knew that this man was a registered sex offender and continued to allow him to work within the scope of the ministry. For nearly 20 years, I told no one, not even my wife. And myself and 5 friends, I'm getting ahead of myself. I was one of the first victims to come publicly forward in 2023. Myself and 5 friends, some of whom were even still pastors in the Assemblies of God, started making calls to friends, figuring other men had been abused, and we had heard dozens of stories of abuse and started to try to help the over 40 victims that we found to get help, seek justice, and just to heal. We watched in horror as NDAs were used to insulate organizational leadership to cover themselves, using the NDAs as a fog of ignorance and hiding behind it. Because of this, the justice has not been served. Since then, the Assemblies of God has tried to dismiss valid civil claims of negligence, sideline victims like myself in the investigation process, and has even sneakily tried to get minor victims to sign NDAs. I'll also add that I'm a high school teacher here in Texas, and every year, to reiterate from the witnesses earlier, I have heard stories of sexual harassment and sexual abuse from students. My wife and I have a rule in our house with our kids: no secrets. Last night, I was talking to my 8-year-old daughter, and I explained to her in 8-year-old language the process of NDAs and child sexual abuse, because it's a heavy topic for an 8-year-old. And She said in her 8-year-old language, "But if you keep it secret, doesn't the bad person keep hurting children?" Her 8-year-old brain automatically understood that. There's a quote from Supreme Court Justice a long time ago, Louis Brandeis, saying, "Sunlight is the best disinfectant," referring to the power of transparency and openness to expose and combat corruption and wrongdoing. My request is that we pass Trey's Law, as this bill would allow accountability and justice to take place, and it will not allow organizations such as the Assemblies of God and leaders to plead agnosticism in the face of these unspeakable crimes, and it will bring truth and light to the situations in desperate need of truth and light. Thank you.
Thank you. Thank you, Mr. Cleveland. Very sorry to hear about your story, but we appreciate your
Thank you, sir.
courageous testimony today. Thank you, members. The chair calls Curtis Garrison. Curtis, I have you here on behalf of yourself and on behalf of SOS CSA.
Yes, sir. That's Speak Out to Stop Child Sexual Abuse.
Speak Out to Stop Child Sexual Abuse, and you're registered for House Bill 748. Is that correct?
Yes.
Okay, go ahead.
First, I want to say thank you for everything that's been said from you guys, because I've never heard anything like that. Not the support that you're doing today. It's unbelievable. Okay, I'm Curtis Garrison, and I'm a child sexual abuse survivor. For my adopted dad as a toddler, that I grew up to know that I had seen my adopted siblings and several foster children being sexually abused. And then I was abused in my Boy Scouts troop from age 12 to 15 in the 1980s. I am now 55 years old, and I've been fighting for justice my whole life. NDAs are laws that protect predators. I am one of the 82,209 BSA bankruptcy claimants. It's been over 5 years since the Boy Scouts of America filed for bankruptcy, February 18th, 2020. And we're losing approximately 100 claimants a month, waiting and dying for justice. The trauma, divorces, job loss, high blood pressure, blood sugar, they're losing eyesight, physical ailments they're dying by suicide. The carnage is costing our society unbelievable amounts, and people see these people walking around, have no clue what they're suffering. Silence is further abuse. Silence is violence. Silence is deadly. It took over 4 decades for me to work around NDAs and statute of limitations to even have a chance to be heard. Unfortunately, the bankruptcy process is another way to try to silence us. The BSA has NDAs with claimants that's settled out of court. They have NDAs with their employees, especially when they leave or they'll lose their pension plans and benefits. My perpetrator was a known perpetrator that was before my troop and after, and the Boy Scouts of America did not warn anyone. Since their beginning, on average, thousands of children were sexually abused every year for decades, and a known perpetrator was reported to the headquarters every other day, every year for decades. Tens of thousands of these perpetrators in their files, and they're still hiding them. They're redacted or not known in what they've released. News coverage started with them since the 1920s. Like New York Times had an article in the 1930s about thousands of perpetrators known and hidden because of NDAs and their policies of not reporting. Protected perpetrators continue to sexually abuse children. They die before they're held accountable, and survivors don't get their chance for justice. Survivors have the heavy weight of shame for thinking they're to blame for allowing this abuse to continue, especially when they see that others have been abused after not being able to stop these perpetrators. Justice delayed is justice denied. If laws don't provide accountability, then these laws have to change. I don't even know how it's possible that these laws exist to hide a crime that's so vile and disgusting and harmful. It costs us for our whole lives, and everybody is suffering from our trauma and struggle. I mean, I'm not married and don't have any kids, okay? That's a loss for whatever my family tree could have been to contribute. Thank you for helping child sexual abuse survivors be heard.
Thank you. Thank you for your testimony, Mr. Mr. Garrison. Again, I'm sorry about your story as well, but tremendous act of courage to be here in front of us today, and we're grateful for that. The chair calls Christina Green. Christina, I have you here on behalf of the Children's Advocacy Centers of Texas testifying for the bill. Is that correct?
Yes, sir.
All right, go ahead.
Christina Green, Chief Advancement and External Relations Officer with the Children's Advocacy Centers of Texas, here in support of House Bill 748. And I represent the 70 children's advocacy centers across the state that serve children in all of your districts, 60,000 children a year, and the majority of those are child sexual abuse cases. And I'm so grateful for the brave survivors that you've heard from today and for their stories, because that's how we propel progress. That's how we propel justice, and that's how we keep our communities and our children safe. Unfortunately, though, these stories that you have heard are not unique. We have over 60,000 children every year walking into the doors of our children's advocacy centers that are experiencing crime, the majority of those crimes being child sexual abuse. And their stories are very similar. They have the same threads around grooming, around secrecy, around people they know and love and trust that have perpetrated these acts of violence against them. There's been some conversation about the scope, and that 1 in 8 number is a national number in Texas based on new data that we've worked with the Department of State Health Services and the CDC to gather. It's 1 in 6. With 7.5 million children in this state, this is not something that we have the option of sitting on. We have to take action. And this is one of a suite of pieces of legislation before this body, many of which you all have authored on this dais, to keep our kids safe. We need to make sure also that we are not just responding, because we cannot investigate and prosecute our way out of this. We have to prevent it. And one of the main ways we prevent this is preventing secrets and allowing our victims to actively speak out about their abuse, both so that they can attain safety, justice, and healing, but also we can keep future children safe, because we know that the dynamics, the perpetration of these acts of violence against children are by perpetrators that will offend again on the same victim and with multiple victims after that. So I'm grateful for this body. I'm grateful for the conversation today. This is a marked change. It is.
Yeah.
And I feel it deeply, having worked in this area for over a decade and a half. And I want to shout this for the rooftops for our 70 children's advocacy centers that are out there in the field doing the work with these survivors and brave child victims and their families every day. Because the one thing that they say to us as their state association, as the leader up here to advocate for them and on their behalf and on behalf of these children, is how do we stop the funnel of kids coming in our centers? We want to put ourselves out of business. We don't want the state to have to continue to increase funding and policy measures to help making sure children are getting to us and we're able to serve them after they've already experienced abuse. And this is a huge step in that direction. So thank you for your advocacy, and thank you for your continued investment in responding to, but also preventing this.
Thank you. Thank you, Christina, and thanks for your work. The chair calls Jennifer Allman. Jennifer, I have you here on behalf of the Texas Catholic Conference of Bishops, registered for House Bill 748. Is that correct?
That is correct.
Thank you. Go ahead.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops, and I'm testifying in support of House Bill 748. I, too, want to thank the previous witnesses, all of the survivors who have have used a great amount of courage and tenacity to tell their stories and the stories of their loved ones. The Texas Catholic bishops are committed to using all efforts to end the evil of sexual abuse. Over the past 24 years, the reforms within the Catholic Church have strengthened communities in which the Church is present. Prohibiting non-disclosure clauses in civil settlement agreements involving sexual abuse claims recognizes the value of transparency. However, such a prohibition should respect survivors' right to privacy when the inclusion of such clauses is at the option of the survivor. So I want to thank Chairman Leach for the comments that you made about those who really don't want their story told. The Catholic Church does not enter into settlements in sexual abuse cases which require confidentiality agreements for the church to keep quiet. We do allow survivors to say that the church cannot disclose their name. We do disclose the name of the credibly accused priest, however, or clergy. And because we publish those names, sometimes that's why survivors ask us to sign an NDA protecting their confidentiality so that they are not connected to the case. We believe this bill empowers survivors. The only concern we might have about the bill is how the retroactiveness at the end of the bill will work. But regardless of how that provision works, it is the policy and practice of the church in Texas not to use non-disclosure agreements of this type. So we still support the bill. I want to thank you, Chairman Leach and Vice Chair Johnson, for your efforts to shine a light on childhood sexual abuse to encourage transparency and healing. It's methods like these, as well as all of the bills before the legislature on background check, closing loopholes, that will help us to further prevent abuse and to ensure that our culture is a culture of see something, say something, and is a culture of telling. That is what we want to instill, and we think this bill helps to do that. So thank you.
Thank you, Jennifer. Members, any questions? Yes, Representative Flores.
I just want to say thank you to this panel and to the previous panel for coming forward and helping this committee and the legislature remove a very horrific tool from a toolbox for predators and perpetrators. So I thank you, Chairman, for bringing this bill up.
Thank you, Representative Flores. Members, any other questions for the panel? Okay, thank you each for being here. Thank you, gentlemen, for your courage. Elizabeth, you come sit back up here. I just want you to have a front row seat to this. Members, is there any objection to the adoption of the committee substitute for House Bill 748? Seeing none, the substitute is adopted. Representative Johnson, Vice Chair Johnson, moves that House Bill 748, as substituted, Trey's Law, be reported to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Leach.
Aye.
Johnson.
Yes.
Dutton. Moody. Landgraf. Schofield. Gonzalez. Flores. Hayes. LaHood. Dyson.
There being 10 ayes and 0 nays, the motion prevails, and Trey's Law will be reported to the full House with the recommendation that it do pass and be printed. Thank you and congratulations. Members, the chair moves that the committee stand in recess until final adjournment, recess of the House, or during bill referral if permission is granted. Is there objection? Seeing none, hearing none, the motion prevails and the committee stands in recess.